Okay, calling the next case, which is People versus Soriano. This is also a mini oral argument on the application. 15 minutes of argument per side. Counsel for appellant, so 15 minutes per side, 2 minutes of fire-free zone, which may be waived, and obviously if you would like to reserve some time for rebuttal, you may. We just ask that you try and keep track of that yourself. But proceed.
Thank you, Your Honor. May it please the Court, Ali Wright from the State Appellate Defender Office. On behalf of Zebadiah Soriano, I'd like to reserve 2 minutes for rebuttal. Courts sitting in the United States should not accept early morning confessions from sleep-deprived drug teenagers who are strapped to chairs. But that's precisely what happened here. A police officer elicited a confession from a teenager who he knew was drugged, who he knew had just experienced a sleepless night exposed to winter-like elements in Michigan, half naked, and who he knew was strapped to a chair. And our courts accepted it. That is wrong, it's unconstitutional, and it's deeply unsettling. If, as reported by Deputy Ruggles himself, Zebadiah was not sober enough to hold a basic conversation with his parents 2 hours after his interrogation, then Zebadiah, a teenager, necessarily was not sober enough during the interrogation 2 hours before to waive Miranda or give a voluntary confession. To understand Miranda warnings, the nature of his Miranda rights, and the consequences of waiving them to make serious legal decisions with serious legal consequences. Now, I'm happy to discuss Zebadiah's case in more detail and answer this court's questions, but there seems to be some confusion among law enforcement and our lower courts, and they could benefit from this court's guidance. So to the extent it was unclear to police before, this court can make clear now in ruling on this case that police officers are not permitted to interrogate teenagers just 1 hour after a sleepless night exposed to elements when they're high and strapped to a chair, even if the police officers were not the ones to personally strap him to that chair or personally drug him. They cannot exploit someone that vulnerable. Now,
What do we do, counsel, with the fact that, while there are facts that suggest, obviously, given the nature of the drug he took and how much, and I think the comment to the parents 2 hours after the interrogation is difficult for the prosecution, but, he was able to talk about the type of drug that he consumed and how many tablets he took, the relationship with the complainant. He was able to recognize that this is a police officer and that's a nurse, and this Miranda doesn't require an in-depth understanding of the rights. Why do those facts not suggest that basically he was coherent enough to make this knowing and intelligently given?
well, first, I guess I'd say, or I guess I'd point out that those facts, one, again, as I'm sure the court is aware, it's the prosecution's burden to establish a valid waiver here. And the facts that the court just identified don't show that Zebadiah understood what his rights were, that he understood he had a right to an attorney right then and there, and that he understood he did not have to answer the officer's questions. They don't go to that, and I asked this court to look at its opinions. I believe it's Cheatham is where this kind of comes up. And those cases are distinguishable because there in Cheatham, the testimony was that the defendant there said, I knew that I had the right to an attorney. I knew that I had the right to remain silent. We don't have those facts here. There's nothing in the record here that explicit from Zebadiah. And I'd also ask the court to look at the rest of the record from the suppression hearing. When Officer or Deputy Ruggles is saying he seemed confused, he's primarily or predominantly giving yes-no answers, head nods, that he's having difficulty with dialogue. Those are all indicia or indices, or they all indicate that this is someone who is not capable of waiving Miranda, and particularly, and I'd remind this court of Zebadiah's age again. This court recently held in Parks that 18-year-old brains are different. Zebadiah's brain was different. He's not an adult, and as a result, he would make at risk of making decisions that an adult would not, to his detriment. And I really do think that Deputy Ruggles exploited that vulnerability.
Counsel, can you respond to the argument raised in the Amici brief regarding whether or not he's in custody in the first place? I mean, it seems to me that that may not have been a central issue between the parties here, but Amici has kind of put it front and center.
You're referring to the PAM briefing? Yes. I respectfully disagree. Whether he was in custody is definitely not an issue in this case. In fact, a review of the transcript from the suppression hearing, Deputy Ruggles admits that Zebadiah was in custody. Specifically, when they find him and arrest him or seize him in the forest, Deputy Ruggles said they cuffed him, that they put him in his car. He's arrested right then and there. So he was in custody from that point all the way to the hospital. As he's strapped to the chair, there's a reason an officer is stationed outside of his door, because he's still in custody, and he goes straight from the hospital to jail the second he is discharged. So I don't think there's any dispute or question as to whether he was in custody. I do think the PAM amicus, their argument was also that, well, Zebadiah didn't need to be Mirandized in the first place. And I find that argument, I don't think that this court should buy into that argument. The standard cannot be, and I believe the argument there is because he technically initiated questioning. The standard cannot be that any question whatsoever asked by someone in custody opens the door to a full-blown interrogation, and that's exactly what happened here. Zebadiah asked a basic question because he essentially woke up from being unconscious and did not know where he was or what was going on. So he asked, where am I? What's going on? That does not give Deputy Ruggles or an officer in that situation carte blanche to start saying, oh, by the way, the weather, yeah, it's 35 degrees outside. By the way, when you were assaulting the complainant, blah, blah, blah. It can't work like that. Any question, it can't be any question whatsoever asked by someone. What the weather is, what time it is, what date it is, opens the door to an interrogation.
Well, it opens the door to further inquiry, right?
I couldn't hear you.
It opens the door to further inquiry into the question of whether it's voluntary or. I mean, the defendant initiated the discussion. That opens the door to us for a reviewing court to look closer at, all right, what's going on here?
Sure, and I think my point was it doesn't open the door. Asking some basic question, what's the weather, what did I have for lunch yesterday, whatever it is, does not open the door and entitle an officer without giving someone with Miranda warnings to interrogate someone about a criminal offense. And that's my understanding of Pam's argument, or the amicus argument there.
Ultimately, the trial court held a hearing and made findings. And frankly, I found our MOA order a little confusing because issue 1 asks whether the trial court clearly erred when it found defendant made a knowing, involuntary, and intelligent waiver, and question 2 asks whether it was an abuse of discretion to deny the motion to suppress. Which standard are we looking at?
I was honestly a little confused by that too, Your Honor. I think under either standard.
Well, no, which standard is it? Come on.
Well, okay, I think this court reviews these things for, this court is supposed to defer to the trial court's factual findings, but it's
For clear
error.
So the questioning initiated by defendant opens the door. The court has a hearing. Why is there clear error in the court's analysis?
Because there are.
I'm sympathetic to your position. Here's a kid who took 6 LSD tabs, running around naked in the woods. Now he's in the hospital, he's restrained. He's restrained by the hospital for his own safety and the safety of the people in the hospital. Police didn't do it. His conduct seems to have changed. He's coming down, and he initiates a discussion with the police officer. And I think our jurisprudence is pretty clear. Intoxication alone isn't enough. He could still be intoxicated, but the question, you got to peel the onion and find out, does he really know what he's doing when he does this? And the trial court is in the position of assessing credibility, hearing testimony, trying to determine who's being more truthful and forthright with me. And the trial court made those decisions. So while I, as a trial judge, might have gone a different direction, I'm having a hard time finding clear error. So can you help me fall more on your side on this argument?
Certainly, Your Honor. I'd point out that the trial court got the inquiry or the test wrong here. It's the totality of the circumstances, and the trial court conflates in its analysis the Miranda inquiry, whether the waiver was knowing and intelligent, with the voluntariness of the confession. And the trial court never once cites Soriano, never once cites Stewart. It kind of just pretends or glosses over those or pretends they don't exist. It doesn't address a lot of those factors that are attendant to Zebadiah's case. And so there's a lot of muddling or confusing of those two different inquiries in the trial court's finally reaching its ultimate determination here. And so I don't think this court, while this court has a developed, I'd say, factual record before it, the conclusions reached by the trial court based on that record, the trial court applied its analysis incorrectly. Again, it's muddling or mushing together these two distinct concepts, and the U.S. Supreme Court has said that our courts are supposed to treat these things differently.
So are you making an argument of legal error and the confusion of Miranda versus I guess, as I understand it, a confusion between what is a waiver of Miranda and what is actually knowing? Is that?
Two points. One, that there was confusion between a knowing and voluntary, the analysis for a knowing and voluntary waiver of Miranda with whether the confession was voluntary. And then second point would be, in addition to the legal analysis being incorrect, the factual conclusions are wrong. The trial court, even based on the record before it, Deputy Ruggles himself saying Zebadiah was confused, that he could not give, much dialogue, yes, no head nods. Zebadiah's testimony that he did not understand the words coming out of Deputy Ruggles' mouth, that he was just responding randomly out of some kind of need to respond to a figure of authority. All these things, and if the trial court had properly looked at the totality of the circumstances, would have, or should have, and I think this court should reach its conclusion, show that the Miranda waiver could not have been knowing and intelligent, and his confession could not have been voluntary.
Okay, thank you.
Counsel, one of the things you argue is that obviously the drug here is mind-altering, and we obviously have precedent that says drug use alone, not enough. You can still, make a clear statement and know what's going on. So are trial courts to sort of assess the impact of whatever the exterior element that's on a defendant? I mean, that's part of the analysis?
I think that's part of it. I mean, I think the type of drug matters. I think at least there's Court of Appeals opinions saying, well, we care less if it's just alcohol, drunk people do maybe stupid things, but LSD is different, acid is different, dropping acid is different. It's a mind-bending, mind-altering drug that causes hallucinations. It's very powerful, and so that is a factor here too, but again, it's the totality of the circumstances, so this court also should be looking at Zebadiah's age, his lack of prior interaction with law enforcement, his intelligence, the fact that he was strapped to a chair, which is not an explicit Soriano factor. However, this court is required to look at all the circumstances of the interrogation. So I'd point to all those things. I do see I only have a minute 20 left, and I would like to save some time for rebuttal. So I might pause there for now.
Good morning, Your Honors. May it please the Court, my name is Kyle Atwood. I'm here today on behalf of the people of the state of Michigan. The trial court in this case, after a full evidentiary hearing, made credibility determinations and factual findings that the Court of Appeals affirmed. Those factual findings are entitled to a great deal of deference, and under Cheatham, Dowd, Burrell, and Stewart, those are not clearly erroneous. The defendant's statements were admissible. The suppression ruling was not an abuse of discretion, was not clear error, and counsel was not ineffective. The facts in this case are very important. I want to highlight a couple of those as they apply to the case. It's important to note that this was a 5 to 10 minute conversation that occurred, initiated by the defendant. It took place in a neutral setting. This was a hospital setting. This was not an hours-long coercive interrogation at a police station after an
Counsel,
arrest.
is it really a neutral setting if he's tied to a chair?
I think it is a neutral setting, Your Honor, and it's been indicated, I think, by Justice Zara that these were medically applied restraints, but he's not handcuffed by law enforcement. He's not in the corner of an interrogation room or a police station. It is a more neutral setting than we could have otherwise. And so the statement that has drawn the most scrutiny here, the I am a rapist statement, it's worth highlighting. That was actually made at the very beginning of this conversation. This was not after extensive questioning by the deputy. At the evidentiary hearing, the deputy testified that he started by asking the defendant to explain the nature of his relationship with the victim. What kind of relationship do you have? The defendant's response was that they didn't really have any sort of dating relationship. And immediately after that is when this utterance came out, the statement that he was a rapist. So it was truly a spontaneous inculpatory statement that wasn't even really responsive to what the deputy was asking in that moment. He was really just asking about the nature of the relationship.
Counsel, can I come at it from a different angle? If this statement were coming from, say, an informant, could the police rely on it? If an informant was tripping off LSD and restrained in a hospital room, just waking up, could the police rely on that statement?
If they were presented with the same indicia of reliability that this statement was, I believe they could.
What does that Brady disclosure look like? When you say, hey, we've got this statement from our informant, he was tripping off acid, what exactly do you have to disclose?
Well, I think the outline, Your Honor, would be the same factual scenario here. The context, the place, the location, the timing, when the acid was taken, how much acid was taken. And after that, in looking at the indicia of reliability, the totality of the circumstances, I think it is a statement that law enforcement could rely on, be it an informant, be it a defendant, any other witness.
Counsel, can you, I'm sorry. Can you help me? There are two facts that I'm sort of stuck on that I don't see were referenced by the trial court. The first being that the officer told the defendant's parents 2 hours after this 10-minute interview that he was too out of it to actually speak. And then the other one is the comment is, I'm a rapist, but he didn't actually, the allegation is that he didn't rape her, correct?
Correct, Your Honor, yes.
And so why, I mean, I'm struggling with why those aren't some relevant facts that actually show, at a minimum, clear error in the factual finding. But again, we look at the totality of the circumstances de novo in determining whether or not the waiver was proper.
So to answer the first question about the call, that was not a factual finding the trial court made, as you've indicated. And Deputy Ruggles was asked about that conversation during the evidentiary hearing, and he did not acknowledge making that call. He didn't have a specific memory of that call. He did indicate that if he had made that call and made the statements that were attributed to him, it likely would have been earlier than the defendant's father remembered it being. There is a
It was
dispute.
after, though, the officer had talked to him.
I don't know that he made that admission. I don't know that he said that. That is what the defendant's father said, or the timing was consistent with that. But the deputy was not conclusive about having that conversation with the father and did not admit that it happened the way that the father alleged it had happened. And obviously, the trial court at the evidentiary hearing is tasked with making credibility assessments. This is the father of a defendant who's had some time to talk with his son about what had occurred. And so the court, rightly or wrongly, I think looked at it through a credibility lens and said, I'm not going to rely on him as a sufficient historian.
Of course, but the trial court didn't make that, in fact, finding.
Did
Right?
not.
I mean, in the record, we don't have that being part of the trial court's analysis.
That's correct, Your Honor. I don't think the trial court commented on that at all.
Right.
As far as making the ruling. But I just respond that it was not something the deputy admitted that happened in the way that it was alleged.
He just
So
didn't deny that it.
he didn't deny it. He did not have a firm recollection of if
Okay.
the call was made, what words he used, or when the call would have happened. But his assumption was that if he had said that, it would have been earlier than the father had indicated.
And
While he
what
was still under the
What
influence.
about the fact that the comment is he's admitting to something that isn't in fact the crime?
So I don't know, and as I mentioned, that did happen early on. It was before any sort of lengthy conversation with him about the allegations. So I don't know why he said that. It could have been, rape means different things to different people. When we interview folks about allegations and they say, I was raped, there's often the follow-up question, well, what does rape mean to you? So we don't know what rape meant to him, or he may have just been commenting that he had a recollection of something.
Well, I mean, it's interesting to me too, because I think, I mean, this goes more to the harmlessness error, but the defendant was acquitted of strangulation, which is what the complainant had also alleged, the assault and strangulation, and he had nothing in his statement suggested that corroborated the strangulation, and he was acquitted on that. So that says to me, why am I wrong to think that the statement, I'm a rapist, I'm effed, means, like, was in fact relevant or were perhaps persuasive to the jury in convicting him on the assault charge?
Well, I guess I can touch on harmless error too here, because there was a lot of other evidence besides that one statement, and I don't know what they attributed to that statement, how much they attributed to that statement, but there was ample evidence outside of that statement with which the jury could have convicted here.
Sorry, counsel, ample evidence of intent?
I believe so, yes.
Like what?
So the victim testified that the defendant had remarked to her when this was occurring, are we going to do this? She said no, at which point he removes his pants, he's completely naked from the waist down. I think it's reasonable for a jury to infer, if you're assaulting somebody, you're saying, are we going to do this? You pull your pants down, exposing yourself, that the intent there, without him saying, I am going to penetrate you or something like that, the intent there, I think, is clearly to have sexual intercourse, and the jury's allowed to make that inference from what they were presented with. But not only that, obviously the victim's mother was there as well in an upstairs room. She was almost down there contemporaneously with this happening. The victim went up, made contact with her mother, was still very frantic, couldn't get the words out, saying that he tried to. She observed the defendant with his pants completely off, exposed. The defendant runs out into the night, again, naked from the waist down. The deputy observes him naked from the waist down. And what wasn't developed below sufficiently, I think, is the defendant's own testimony as well. He did testify at trial, and on cross-examination, he admitted that pretty much all of the victim's testimony was accurate, right up until the time of the assault, at which point he testified he did not have adequate recollection. He had a lapse in recollection at that point. But he did admit that given that lapse in recollection, and given his expressed romantic feelings for the victim, he did admit that could have caused him to do exactly what the victim stated he did. He said, yes, it could have happened. I don't remember. And so, well, that's not a complete confession when combined with the other evidence in the case, observations of the mother, the deputy involved, certainly enough for a reasonable jury to convict. So, assuming, again, arguendo that the trial court erred here, harmless error, I think, should apply. And I want to address issue 3 before my time runs out, regarding whether this was ineffective for trial counsel to fail to obtain an expert on intoxication. It's important to note at the outset that there was not an evidentiary hearing conducted at the trial court level on that issue, the ineffective assistance claim, so we're left with what we have on the record, and we don't obviously know what conversations may have occurred between the defendant and his attorney about paying for an expert or not paying for an expert. So without that information, we look at what we do have, and again, through the lens of a strong presumption of sound trial strategy. The defendant has presented a report from Dr. Kara Poland, who was a board-certified physician. And the striking part about her report to me is that it's fairly inconclusive, and I think that that's probably what the Court of Appeals was looking at as well in that evidence. The findings of Dr. Poland were actually very consistent with the observations of the witnesses of the defendant's behavior that night. Based upon the variables involved, the strength of the LSD, what was actually in the substance, use of other substances. Because of those myriad factors, the most Dr. Poland could say was that the defendant might have been under the influence at the time of his statements. In fact, his own statements about still being out of it later that night were at odds with his own expert. She said, in worst case scenario, the effects would have worn off. He would not have been under the influence at that point in time. But the defendant did, in fact, pursue this intoxication-based suppression of his statements at the trial court level. And again, an evidentiary hearing was conducted. But as we can see in Dr. Poland's report, on their best day, an expert really wouldn't have moved the needle one direction or the other. Her opinion was that maybe the defendant was under the influence, maybe he wasn't. And so with that level of inconclusiveness, we really can't say that there's a reasonable probability that the result would have been different below with that evidence included.
Counsel, so what is your response to the idea that maybe LSD is different than cocaine and it's a mind-altering drug? I mean, I know there's a fact issue whether his mind was still altered, I understand.
Sure.
But, I mean, do you agree with the point that they're different?
They are different. They affect the body differently, certainly.
So does that factor into the analysis, or do we treat all drugs the same? As long as these statements seem clear at the time, then that's it. We don't look sort of underneath what else could potentially be going on.
So we don't treat them the same, Your Honor, but we don't look at a drug and make a per se conclusion about that drug's effect on an individual. So that's where we get into the totality of the circumstances type analysis. So with the recognition that LSD might cause hallucinations or mind-altering effects, we look at the individual, we look at their ability to coherently respond, we look at the things that the trial court looked at to make that determination. We don't look at the substance itself and say, well, LSD, we need an expert, because it affects people differently, as most drugs do, and methamphetamine has a similar effect on some people where they lose recollection. But we look at the effect on the individual, and there are too many factors to make that per se argument that LSD equals incapacity. We look at the totality. So, no, we don't treat them the same, but we also view the analysis in a similar way. We look at the same factors.
Counsel, I have one more question. In your view, I mean, you basically said defendants sort of blurted out, what potentially had happened. So is that when he waived Miranda? Like, when was Miranda waived here?
Sure. I think it was at the beginning when it was given. So it was at the beginning of the conversation, and that was when it was waived.
But we don't have any explicit waiver. It's just...
Not explicit, not an invocation of rights. I mean, he didn't sign a waiver or say, I waive my rights. But given the context of the conversation and his response, the trial court drew a reasonable conclusion that he had in that situation. Lastly, I just want to touch on the practical implications of going down this road. Requiring an expert as a prerequisite to admitting a statement of an intoxicated or potentially intoxicated person would, as a practical matter, convert that into sort of a quasi per se barrier to Miranda waivers. It would result in sort of a battle of the experts scenario at the trial court level in litigation of routine cases. Drunk and drug driving cases, as an example, domestic violence cases involving alcohol or drugs, disorderly conduct, public intoxication cases, theft cases involving, for instance, methamphetamine, sexual assaults where parties have been drinking. In each of those cases, officers routinely take statements from suspects after they sober up enough to converse. So adopting that requirement would kind of throw a wrench into what is a workable analysis and looking at the totality of the circumstances from an external point of view, and really bog down the system with, again, a battle both ways in those low-level cases. I appreciate your time, Your Honors. Thank you.
Thank you.
The prosecutor argued that this was a neutral setting, and I'd really strongly disagree with that statement. Even if I, God forbid, woke up in my own home, strapped to a chair with no idea how I got there or what happened, even I, as potentially an attorney, am more likely to answer questions or just to figure out what's going on or not realize what's going on, so, and have my will overborne. This case, I'd also say the prosecutor ended up talking about, opening the door, the floodgates to DUI cases, et cetera. This case isn't just about drugs. It's about a teenager, a teenager who's, there's all these other totality of circumstances or factors that apply here. Him being strapped to the chair, his age, the drug use, of course, but there's many other factors beyond drug use that make this confession involuntary. With respect to the still out of it statement, I don't think the record, I'm not sure I see the record the way the prosecutor does. That statement from Zebadiah, or from the officer, that admission from the officer, regardless of whether it happened somewhat short in time after the interrogation or 2 hours after the interrogation, it still means that at the time of the interrogation, Zebadiah could not have voluntarily waived Miranda or given or knowingly, intelligently waived Miranda or given a voluntary confession.
Counsel, how do you respond to Brother Counsel's argument that this sort of was a spontaneous statement, that, the officers weren't sort of prying it out of him?
Sure, I don't think that makes the confession any less coercive, or the situation, the circumstances under which that statement, "I'm a rapist," was said, any less coercive. Again, he's strapped to a chair, he's a kid, he's on drugs, he had just less than an hour ago been half naked and running through snow. So yes, even if he says that, that is still an involuntary statement, that's still an involuntary confession. The solution was very simple here for Deputy Ruckles. The answer wasn't, don't Mirandize him. The kid's in custody. The answer is, just wait. Just wait. And the reason I really think that Deputy Ruggles did not wait is because he wanted to see what he could get out of Zebadiah under these conditions. And I don't think it's surprising that when Zebadiah...
Counsel, when you say just wait, for how long?
Until the teenager is no longer high, until he's no longer strapped to a chair. There's nothing that prevented him from being unstrapped to a chair. Until he is no longer just an hour from being out in the winter half naked. And again, the police did come back the next day, and Zebadiah, who's no longer strapped to a chair, who's no longer freezing cold, and who is no longer high, he exercised his rights. And I think that's very telling.
Thank you. The case will be submitted.